So welcome everyone to this new webcast for Ian Ballon. We're here at BCLT, the Berkeley Center for Law and Technology, and this is our expert series webcast, but this is always a special one with Ian. I've worked with Ian, I don't know, probably for 2 decades now, and seen this presentation evolve through the years as these practice groups come online, as new areas evolve. And it really is a highlight of my year to see the evolution of this from one year to the next. The difference is Ian still looks pretty close to like he did 20 years ago. I, on the other hand, have aged appropriately. So, with that in mind, let me give Ian his proper introduction. Many of you know Ian if you're in this space. But if you don't, Ian is co-chair of the Global IP and Technology Practice Group at Greenberg, and one of the more prolific speakers in this space, which means spends a lot of his time sharing knowledge with others in the industry. And that's kind of what makes all of this special for us here at Berkeley. We try to make this information available across the country, and we recognize that Ian and people like Ian are donating their time, their vacation, anything that takes away from their billable hours to share this. And I'm personally grateful. We're grateful here at Berkeley for your donations of time, Ian. And as always, I'm really excited to see what you bring us this year.
Well, thanks, Wayne. Thank you for that very generous introduction. I appreciate that. It's always a pleasure to be here. And we do have an awful lot to talk about, as you can see from the size of the slides. I have included excerpts from my treatise on many of these topics from the 2022 updates. So they are not the most current, and that's because I've got a new book coming out this year, and that will be more current. But the slides are more current. And in this year in review, we're going to be trying to tackle a large number of things. Obviously, one of the first and most important issues that we've been dealing with in tech law has been AI. And last year, one of the big issues is the Beatles issued a new song based on a tape recording from the late John Lennon that was made more than 40 years earlier, and with additions from Paul McCartney and Ringo Starr, and enhancements from the late John Lennon and George Harrison. And that is, one of the great things about AI, all of the new things you're able to do. Here's a picture of me playing with the Beatles. AI, of course, is not perfect. You can see in the background, John Lennon has a mustache, and I don't know that ever happened. But again, it's AI, and you can do almost anything. Here's a realistic picture of me riding a dinosaur, although I don't know why my tie was cut off. I guess maybe I got in a fight with the dinosaur. Here's a more cerebral version of me with the dinosaur. Here I am at Christmas time with the reindeer. Christmas time with the reindeer, 1960s theme, and Christmas time when it's snowing with the reindeer. So there are a lot of things you can do with AI, and we'll talk about AI, of course. Although what's clear and what's unresolved in the IP and related property fields for AI are important to highlight, because there is a lot of law that's really on point and clear, and there are some open issues, particularly with copyright fair use, that we'll talk about. So we'll talk about the latest AI case law trends and strategy. We'll talk about Supreme Court decisions from the last year and new developments from the new Trump administration. Rogers v. Grimaldi, a year after the Supreme Court's V.I.P. decision. The problem of mass arbitration and mass consumer class action. And I'll talk about some litigation strategies and transactional approaches. There's really a lot to say in that area. I've worked with dozens of companies on helping them figure out their best strategy, and have litigated a lot of important cases, including one in the past year where we were dealing with more than 40 lawsuits, as well as thousands of mass arbitration claims. And so I think I have some interesting insights on the strategies to employ, which I will talk about. This is probably as good a place as any to mention that nothing I say represents the views of my clients, my law firm, or even myself. Anything I say is just offered to further the CLE objectives of the Berkeley Center for Law and Technology and should not be quoted back to me in a brief, please, if at all possible. We'll talk about online and contract formation, which should be the simplest issue in the world of tech law, but continues to generate controversial and vexing cases that impact those of us who litigate, as well as those of you who try to avoid spending time with people like me. We'll talk about data privacy, including CPRA, ad tech, and security breach class action litigation trends, important cases and compliance issues. There are some First Amendment service provider CDA issues. A big trend in 2024 and 2025 deals with children and lawsuits brought on behalf of children, particularly teenagers, as anything involving child privacy is subject to COPPA, and COPPA has a fairly broad preemption provision. But that's something to be aware of. We'll talk about wiretap scams, mass arbitration, and what your terms of service, terms of use, or EULAs should provide for in 2025. As you can tell by my use of the term scam, which I don't really mean in a pejorative way to the very smart plaintiffs' lawyers who bring these claims. I represent defendants, not plaintiffs in these type of cases. So I should put out my bias in advance if you hadn't figured that out from my use of the term scam. We'll talk about data reuse and AI, the law and liability issues surrounding machine learning and generative AI, and the future with Trump, at least for tech law. Not necessarily for the rest of the free world or even this country. But let's start at a place, because a lot has happened in the short time period that Mr. Trump has become president again, relevant to the tech world. And here are, I think, some of the major takeaways where we are at this point. And I'm recording this on February 24th, 2025. So there's likely to be new developments, perhaps even later this week, just with that disclaimer. So the first and one of the bigger issues to talk about is AI. Under President Biden, we had an executive order that provided guidance focusing on safety and security, privacy, AI bias and civil rights, consumer, patient, and student protection, worker support, innovation and competition, and international AI leadership, as well as federal use of AI. That was completely rescinded on President Trump's first day in office, and based on a new January 2023 AI order, we have in place the focus yet to be determined, but primarily on deregulation. Antitrust, we now are in year 9 of a new approach to antitrust from the time of Presidents Reagan to Presidents Obama. We had, although some fluctuation, with Republicans taking a somewhat more laissez-faire approach to antitrust and Democrats taking a somewhat more heavily regulatory approach. We have moved past the Reagan era, and under both Presidents Trump and Presidents Biden, we've seen renewed aggressive antitrust focus, particularly with respect to so-called big tech, whatever that means. And I think we're going to see that in Trump too, as well, with the caveat that some leaders of big tech companies have been big donors to President Trump and have tried to align themselves with President Trump. And so it's unclear whether those companies will get quite the same scrutiny that other so-called big tech companies have seen. But the focus does remain on this populist hostility to so-called big tech. CDA regulation, this is another interesting area. You haven't really heard a lot talked about it, but I think we really need to be aware of this in the new Trump administration. In the dying days of Trump 1, in June of 2020, President Trump signed the Preventing Online Censorship Executive Order, which called upon the FCC to issue implementing regulations under the Communications Decency Act. The CDA, as I think most of you know, is a provision in law that provides broad immunity from both state and federal claims for secondary liability against interactive service providers. And it really is a law upon which U.S. dominance in the tech world was built starting in the 1990s and has continued for many decades since that time. President Trump, although he has personally benefited from the CDA in personal litigation involving his businesses, has not been a fan of the CDA, or for that matter, big tech. And he asked his FCC to issue regulations, greater government regulation of tech companies. At the very end of his administration, this was repealed by President Biden. There has been no action taken at this point, but I think it's safe to assume that attacks on the CDA may return. Now, we've also seen a change in the landscape. Back in 2020, you had Twitter with robust content moderation policies. Today in 2025, Twitter is now X. It's owned by Elon Musk, President Trump's bro, and substantial major donor who donated over $250 million to help elect President Trump. In addition, we've seen that Mark Zuckerberg, the CEO of Meta, announced shortly before President Trump's second inauguration that he was rescinding most content moderation policies for Facebook and moving the company's moderation department to Texas. So it remains to be seen whether we'll see the same level of interest in regulation. I think it's fair to assume, based on what we've seen, that a lot of policies regarding the tech world are going to be intensely personal to President Trump rather than reflecting broader strategic initiatives. So it remains to be seen. But I think focusing on the CDA and possible FCC regulation would be a smart thing to do in terms of watching where things are going based on what we saw at the end of Trump 1. In the consumer regulation area, we expect, to some extent, a less regulatory approach than we saw in the Biden administration. And there are some Biden initiatives that have been frozen, but the impact of the freeze is not entirely clear. So there was an initiative to try to roll back arbitration provisions. Again, I'm not the best person to predict where things go, but I think we will see less zeal on the part of the FTC under the Trump administration, and really under Chairman Ferguson to roll back the enforceability of arbitration provisions. Similarly, there were efforts to roll back NDAs. President Trump personally is a big fan of NDAs, as we know from all of his personal litigation, including litigation with Stormy Daniels and other women with whom he had affairs. We know he's a big fan of NDAs. I think, given that so much Trump policy is personal to him, I think we can assume that there will be less zeal on the part of the Trump administration to roll back NDAs. The other interesting one to look at is the rule concerning recurring subscriptions and other negative option programs. That was a Biden FTC rule issued November 15th. It took effect January 14, 2025. President Trump, on the day he took office, signed an executive order freezing all pending regulations. So this was not a pending regulation. This was an existing regulation. However, The compliance deadline was not set to take effect to May 15th. So it's really unclear at this point whether the Trump freezes this rule because the compliance deadline is yet to take effect, or whether it does not freeze this rule because the rule took effect on January 14th before President Trump was inaugurated for the second time. From a compliance standpoint, as a practical matter, a number of states impose requirements analogous to what the FTC rule requires. So I don't think this is a situation where companies can completely ignore these requirements, but there is some uncertainty and likely at some point between now and May 15th or later in the year, we'll have some clarity from the FTC. Another issue involving the FTC where we need to see where things are going has to do with the COPPA amendments. We have amendments proposed by the Federal Trade Commission on January 16th under President Trump's regulatory freeze executive order. Those are frozen. They do not take effect. However, that does not mean they will be gutted completely. Again, hard to predict the future, but President Trump nominated FTC Commissioner Ferguson to become the new chair of the FTC. And if you look at his concurring statement in the COPPA amendments from January 16th, 2025, you're likely to be able to look into the looking glass and forecast where things will go. He largely agreed with the COPPA amendments, but he disagreed in particular with two major provisions. And again, hard to predict the future, but I think it's reasonable to assume that at some point we will see new revised COPPA rules that track FTC Chair Ferguson's views, which would be a skinnier version of what had been adopted by the prior FTC on January 16, 2025. Finally, another interesting issue has to do with the Patent and Trademark Office. For those of you in the IP space, you're well aware that the Patent and Trademark Office operates largely in a remote capacity. 96% of their employees permanently work remotely, and that's intentional. That was an intentional PTO policy. Nevertheless, President Trump signed a return to work order requiring all federal workers to go back to their offices or be fired. The PTO doesn't even have space for most of their 13,000 employees, even if they wanted to return to a physical office. So remains to be seen how that's going to shake out. But unless there's some exemption, what that may mean is that in 2025, patent and trademark applications and office actions are going to start moving much more slowly if there is a mass exodus of employees from the office. So let's turn now from the executive to the Supreme Court. We had a number of interesting decisions from the U.S. Supreme Court in 2024, and we also have one that I want to flag for you on the agenda for 2025 that you should look at if you work in the marketing space or are concerned with text marketing or the TCPA. So let's run through the cases, starting first with Vidal v. Elster. That involved the Trump Too Small trademark. Someone applied for that trademark for T-shirts. The U.S. Supreme Court had issued a couple of very significant First Amendment decisions in the past few years, striking down trademark regulations that were found to infringe upon First Amendment rights, and many people thought that that would be the case here. There is a Lanham Act section prohibiting registration of a trademark that consists of or is comprised of the name of particular living individuals without getting the written consent of those individuals. This was obviously a critique of now President, at that time, former President Trump. nonetheless, the Supreme Court, in a decision written by Justice Thomas, ruled that this provision of the Lanham Act was not a viewpoint-based regulation and therefore did not violate the First Amendment, and the applicant could not register Trump Too Small as a trademark, as Mr. Trump did not provide his consent. A narrow but interesting decision, particularly in light of two prior U.S. Supreme Court decisions striking down provisions of the Lanham Act under the First Amendment. The next decision worth looking at that's quite interesting is the Warner Chappell Music v. Neely decision from 2024. The holding in that case is that a plaintiff with a timely copyright infringement claim under the discovery rule is entitled to damages regardless of whether the infringement occurred. Now, if you take that decision alone, that seems pretty straightforward. The Supreme Court assumed without deciding that the discovery rule applies to copyright actions. And so it doesn't really fully address the case. There's still a circuit split on that issue, and it leaves that question open for further analysis, which means more litigation. But I found this decision troubling because it's inconsistent with the Supreme Court decision from literally 10 years earlier. In Petrella v. Metro-Goldwyn-Mayer, Inc., 572 U.S. 663, the U.S. Supreme Court held in 2014 that laches is not a defense to a copyright infringement claim because the copyright statute has a 3-year statute of limitations, and that takes care of the issue of delay. And I think it's hard to reconcile these two decisions unless you either overrule Petrella or you hold that the discovery rule does not apply to copyright claims. Because if the discovery rule applies to copyright claims, there should be a laches defense, unless you construe the discovery rule in such a way that it subsumes essentially laches, which I suppose the Supreme Court could do. But otherwise, if there is a discovery rule, then potentially a claimant who sits on their rights for decades, as was the case in Petrella, could sue for decades worth of damages. And in the Petrella case, the Supreme Court said that was not a problem because a copyright owner shouldn't have to sue every time there's an infringement. They may want to wait to see whether the infringement is significant or whether it's insignificant, since federal litigation is costly. And then if it turns out to be a problem, then they can sue, but they're limited to 3 years of damages. So I think Warner Chappell v. Neely inserts some uncertainty into copyright law that we thought we had after Petrella v. MGM. And I think this is going to have to be resolved at some point again by the U.S. Supreme Court. Another Supreme Court decision from 2024, Murphy v. Missouri, that held that social media users in states lacked standing to enjoin government defendants from allegedly pressuring platforms to suppress protected speech. That involves the question of whether and to what extent government agencies can tell social media companies what to do. And that issue remains unresolved because it was deciding on standing, which again seems to be, well, I don't know how to say this in a polite way, but one would think that that social media users in states would have standing in this kind of case, but apparently not. Linke v. Freed deals with another issue of the intersection between social media and the First Amendment. The court held that under the state action doctrine to establish 1983 liability, a social media user suing over a city manager's conduct in deleting user comments and blocking the user from his profile was required to show that the city manager had both actual authority to speak on behalf of the state on the particular matter on which the comment addressed, and that he purported to exercise that authority in the relevant post. So that gives politicians greater flexibility to block users and delete comments, and requires greater sharpness for any kind of action to prevent that kind of blocking. So that is how the Supreme Court decided that issue. Then, on the other hand, another First Amendment social media case, Moody v. Net Choice. In that case, the court held that state social media laws from Texas and Florida were largely invalid under the First Amendment that required social media companies to disclose how their algorithms work and to do a number of things, and it created a cause of action to allow users to sue in the Texas law. That's a very significant First Amendment win for social media companies. The case I mentioned that you want to watch if you're in the digital advertising space is McLaughlin Chiropractor v. McKesson, but it actually has broader application to any area of law involving administrative regulations. In 2024, the U.S. Supreme Court issued a very significant decision in Loper Bright Enterprises v. Raimondo, overturning Chevron and holding that federal courts are not necessarily bound to give deference to administrative rulings. This is a very significant decision and has broad implications, not just in tech, but to environmental regulation, to a whole host of issues. Any area of law involving administrative regulation. And it also, it impacts a wide array of statutes where Congress delegated to administrative agencies expressly or impliedly the ability to regulate. McLaughlin v. McKesson addresses the question of whether FCC regulations are construing the Telephone Consumer Protection Act are binding on courts. And this decision could be decided very narrowly, just based only on the narrow question of whether faxes sent to an email boxes are deemed faxes and therefore subject to the TCPA, or emails and therefore outside the scope of the TCPA. Or it could be decided much more broadly and implicate an array of FCC regulations. For those of us who defend TCPA class action suits, you're well aware that in 2024, there's been a host of lawsuits brought under the FCC's timing rule that requires that calls take place during set hours, not too early in the morning, etc. I think there's a very significant open question after Loper Bright Enterprises whether courts are bound or really can just ignore that time regulation in addressing the numerous claims brought in 2024 as lawsuits by people alleging that text messages were sent at the wrong time. So very significant. The TCPA, we've seen there was over the last 10 years a huge volume of litigation, but in the past year in 2024, we see a significant decrease in that volume. In fact, if you go on Westlaw, you'll see there are only 16 circuit court opinions in 2024 compared to 33 in 2023. And most of those involved insurance disputes. So we're seeing less of that litigation, but keep an eye on McLaughlin v. McKesson, and frankly, keep an eye on it not just for digital advertising, but for further extension of Loper Bright. So let's turn now to the discrete areas of law that I'm going to cover in the next approximately hour or so that I have remaining, starting with generative AI law and the IP and adjacent legal claims that can be brought when third-party content, data, or information is used to train algorithms. Of course, we know you can use your own data. You can use data that's in the public domain. You may be able to use data, content, and information subject to open source licenses as long as you comply with that. But most of the litigation, most of the advice that companies are seeking in this area involves third-party content, data, or information. Third-party content is potentially entitled to copyright protection, and the copyright law provides strong protections. It also preempts a lot of adjacent remedies. Data and information may be unprotectable because we know under the Copyright Act that facts are unprotectable, or it may be protectable if there's sufficient creativity, or even, or if it's a compilation of unprotectable facts, if there's sufficient creativity in the selection, arrangement, or organization of the data or information, that may be entitled to copyright protection, but it would be entitled to what the U.S. Supreme Court has called a thin level of protection. And thus, if an entire database of unprotectable facts is copied, then that may be infringing unless it's a fair use. But if only selective data is copied, let's say 40%, 50%, maybe even 50% or more, there's no actual bright line, that may not rise to the level of virtual identicality or an enhanced substantial similarity, depending on the term used, either in the Second Circuit or Ninth Circuit, when you're dealing with thin copyrights in factual compilations. And so oftentimes in the copyright area, you may be dealing with the question of intermediate copying, where unprotectable databases or facts or information is copied, an intermediate copy is made, then it's deleted, and then only some percentage of those facts are extracted and used to train the algorithms. And so then the question is whether that intermediate copy was infringing, and that, or a fair use. That may go to how long it was retained, the purpose for which it was retained. Is this a publicly searchable database? Are you a nonprofit organization? Is this a database of your direct competitor used to allow you to compete more effectively? So there are a lot of open questions. There also, of course, are issues involving accuracy with AI, and that deals with potential liability issues that can arise because AI can hallucinate, and we see that less frequently, but still quite common. This was with ChatGPT 3. We're now several versions past that, and I wouldn't expect to see this kind of hallucination today. But with newer versions of AI, AI can hallucinate. I asked ChatGPT 3.0, who is Ian Ballon, and it was, first of all, very complimentary. Let's just say that AI is very generous, really as generous as Wayne Stacy was in giving his very kind and overly generous introduction to me when we started this presentation. It not only identified the things that I've actually done, my position at Greenberg Traurig, my position as a technology litigator, but it also said that I head our firm's blockchain and digital assets practice group. Barbara Jones, who heads that group, would be wise to know. It also said I wrote a book on blockchain. I've written a number of books, but not on blockchain. I do have one on AI data protection and AI copyright coming out shortly, but not that book. But AI, does a lot of things, and sometimes better, sometimes worse. This is my Facebook profile because using a common off-the-shelf AI program, it made me look better than I'm ever going to look. Here I am with my Meta AI glasses, and I don't look that good. So that's my Facebook profile. On the other hand, here I am with 3 sets of teeth, and that's concerning. I don't have 3 sets of teeth. see. And then here I am with a short sleeve t-shirt. I mean, short sleeve suit. And that's just wrong. So AI is a very good technology. Sometimes it doesn't get it all right. There are ownership issues with respect to AI. That has largely been static in 2024. The law continues to be that AI cannot be an author for copyright purposes under U.S. law, and cannot be an inventor for patent purposes. Obviously, at the margins, AI tools can be used, and this may change. But most of the disputes involve this issue that I'm focusing on, which is using third-party data, content, or information to train algorithms. This is also your 2025 eye exam, very small print. That's because there's a lot to discuss. I've included an excerpt from my treatise from the 2022 version, which is over 140 pages long. And it's not just because brevity isn't my strong suit. It's because there really is a lot to talk about. A more current version will be coming out later in 2025 in my forthcoming book on AI and property rights. But the upshot for 2024, the law has remained largely as it has been the last year or two, with some new opinions. You have certain claims which are easy for rights owners to assert, but have remedies that are not necessarily as easy to achieve. And then you have remedies, you have claims with very strong remedies, like copyright infringement, where statutory damages can be up to $150,000 per work infringed, or the anti-circumvention provisions of the DMCA, which also, like the Copyright Act, provide for statutory damages, although at a lower number than the Copyright Act, and also allow for attorney's fees. But you have to, a rights owner has to go through a lot more hurdles. You have to jump through hurdles in order to state a claim. So we see in the contract area some cases, first of all, where Meta was successful. Breach of terms of use. If you have an enforceable terms of use, EULA, or other online contract, or a written contract, at the end of the presentation, I'll be going over some recent case law involving online and mobile contract formation. The law constantly changes. I do recommend that companies look at this every 6 months, because there are problematic decisions that continue to be issued. We saw that in 2024. We'll see it again in 2025. But then you also have decisions like X Corp, where you have a judge declining to enforce X's terms of service. Copyright protection, we talked about the issues with copyright protection, particularly facts versus creative expression, and then this issue of intermediate copying. We've got a number of decisions that have now come out, including several in 2024. The Tremblay v. OpenAI decisions are worth reviewing. They track the analysis from the 2022 edition of my treatise that I've enclosed. They go through a lot of the claims. Interestingly, most of the claims, other than copyright, are jettisoned in that case. The plaintiffs were not able to state a claim. There also are other reminders. Individual rights owners can't sue unless they've got a registered copyright. Other provisions in those cases are worth looking at as well. But the kind of claims that are listed here, as well as a right of publicity claim, jettisoned, with the core copyright claims remaining. Then you have the Anderson v. Stability AI case with a number of decisions from 2024. In that case, there also are a number of issues. Again, copyright being the primary one. And in fact, in Kadri v. Meta strategically didn't even challenge the copyright claim on a motion to dismiss. They simply moved successfully with respect to the other claims. The other claims are the ones listed on the board and in the excerpt. There are potentially common law claims like misappropriation, but those may be preempted by the Copyright Act. Unfair competition, also potentially preempted by the Copyright Act. Trespass and conversion rarely applies because a common law claim for conversion, you have to dispossess the rights owner of the res. And when you're dealing with digital copying, what you typically have is a complete digital copy. Both the original owner and the alleged converter have copies, and therefore that's not conversion. You might have a claim for trespass, but many jurisdictions, including California, require a showing from the restatement of substantial intermeddling with the res, which in California and many cases has been construed to mean impairment of server capacity, unless a party accessing a database to train algorithms is doing so repeatedly. It's unlikely to impact server capacity, unlikely to be a common law claim. In 2024, there was an important Ninth Circuit decision in the trespass area. Best Carpet Values v. Google, finding no trespass claim where a website was displayed in a frame and a copy of a website was made. Again, a decision worth looking at if you're dealing in this area, or if you deal with the issue of frames, which has been a back burner issue for about 3 decades. Got a lot of attention back in the 1990s, but as we in the tech law world know, these issues, like Nietzsche's eternal recurrence, they always come back, and they come back again and again. Interference with contract or prospective economic advantage, potentially a claim. Computer Fraud and Abuse Act, that's a federal anti-trespass statute. Doesn't require a showing of substantial intermeddling, but it does need to show a minimum of $5,000 damage to sue. That's why it hasn't worked so well in consumer privacy class action litigation, but certainly where a rights owner is suing because information, content, or data has been taken to train algorithms for generative AI, the $5,000 threshold is usually easy to satisfy. Even a forensic investigation can satisfy that in most circuits. The anti-circumvention provisions I mentioned, that's potentially an issue, again, depending how information is accessed. If information, data, or content is accessed by circumventing access controls or copy protection mechanisms, then the owner may claim statutory damages and attorney's fees. There is a circuit split, as I talk about in the treatise excerpt that I've included, between one circuit that holds that even if there is a circumvention, a claim may not be brought if what was actually taken is itself unprotectable data under the Copyright Act. A different circuit holds that the DMCA does not create exceptions. It's a clear-cut statute, and therefore, if there was circumvention of access controls or copy protection mechanisms, there is a claim regardless of whether what was copied is itself copyrightable. So there is that circuit split. There are other laws that apply as well, like the California bot law, and I discuss those in greater detail in the materials. Briefly, what I was talking about is primarily an issue of direct liability if a company or individual accesses third-party content, data, or information for the purpose of training algorithms. But there also potentially are secondary liability issues. First of all, for individuals or companies that use off-the-shelf products. That's why most companies offer indemnification for commercial products, but you need to read those very closely because it's a contract right, and it may or may not apply to your particular use. But also this is relevant because many companies that actually use third-party data, content, or information without permission don't do it directly. They hire a third party. Maybe they hire a third party in a foreign jurisdiction where this kind of copying is generally permissible. Maybe they use an unrelated third party. So there are secondary issues that can apply. That's particularly true in the IP area. There is potentially a claim for secondary copyright infringement. Unclear, and not necessarily the case, that there is a claim for secondary DMCA violations. But again, it depends where you sue or are sued. There isn't typically a claim for secondary torts. However, tort law concepts allow for similar approaches, so you may not be able to sue for contributory breach of contract, but you could potentially sue for interference with contract. In general, what this means is, from a transactional perspective, you need to look at, what was copied, how was it accessed, how is it used, how long will it be retained, and what was copied, and was the material factual, functional, or artistic, highly creative? What's it being used for? Is this a direct competitor copying data to be able to compete more effectively, or is this a company or a library offering a general purpose search tool? So these are all issues to keep in mind. As I mentioned, when you're dealing with copyright infringement, there's the potential for statutory damages up to $150,000. This slide provides a quick overview of the law of copyright damages, which allows a copyright owner to sue either for actual damages, which in the copyright owner's sole discretion can be both the alleged infringer's wrongful profits and, to the extent not duplicative, the copyright owner's lost revenue, or to sue for statutory damages, $150,000 per work infringed. So what is a work becomes really important in the AI area, because if you've got multiple compilations that have been copied, is it one statutory damage award per compilation, or is it one for each protected work within that compilation? And that remains an issue that continues to be litigated in 2025 in different circuits. UMG v. Grand Communications, an important Fifth Circuit decision that my firm was involved in, held that a registered compilation is eligible for only one award of statutory damages rather than for multiple awards for each song in an album registered as a compilation. This is a significant decision, but again, that's the Fifth Circuit. It doesn't necessarily resolve the issue. It's also a music issue. It doesn't necessarily resolve it for all time, for all purposes. And then, of course, there's this issue of timing. Are you looking at only the last 3 years, which is what most copyright lawyers assumed prior to 2024, or because of the 2024 U.S. Supreme Court decision in Warner Chappell that I talked about a few moments ago, do statutory damages for copyright infringement now go back further in time? So this is a real issue. Fair use is the heart of where some of the cases in litigation are likely to be decided. We have some important decisions from earlier, not 2024, so I'm not going to get into them in great detail, but we had the Google v. Oracle case, a significant decision, finding by a 6-2 decision that Google's unauthorized copying of APIs for the purpose of creating the Android operating system language was a fair use. I think that's a good decision, as I represented Google in the trial court on the copyright issue in that case. So I'm not exactly an unbiased source. But then a somewhat different U.S. Supreme Court a year later in the Andy Warhol v. Visual Arts case, deciding only the issue of the first factor, which gummed up the case a little bit, held that the use of a photo on the left for Warhol's painting on the left was not transformative enough to be a fair use. Again, the Supreme Court didn't consider all of the fair use factors, and that's important because they sort of gummed up a fair use by importing impact on the market to the first factor, and holding that that this was not transformative enough. Supreme Court in this case goes into great detail. It's a hotly contested decision, but what it really means in the fair use area for copying content is, first of all, are the parties direct competitors? If they're direct competitors, less likely to be fair use. Is the copying transformative enough? Because Warhol put in this concept of being transformative enough. A work can be transformative, but still not transformative enough to be a fair use. I think the easy cases are going to be the ones where the plaintiff can show that the defendant had access to the plaintiff's work, which can't always be shown in these cases, but where they can show it, and they can show that the output is substantially similar to the input. So AI can be trained not to infringe, but again, AI doesn't yet always do exactly what we want, and it may never. It may operate in a mind of its own. And so if the output looks like the input, then that's a clearer case. If the output doesn't look like the input at all, then the question really is, was the intermediate copying, excuse me, a fair use because you trained the AI to do these wonderful and brilliant things, which under existing case law seems to be highly transformative? Or is it not a fair use because it adversely impacts the market for the genuine product? Or again, other factors that may all play out somewhat. We see some decisions coming down the pike since Warhol, none really having bearing on AI, but we see that in the Keck case, the Fifth Circuit found in a case that my firm was involved in that the work was highly transformative, unlikely to devalue plaintiff's work, and therefore was a fair use. Hachette Book Group v. Internet Archive, holding that the Internet Archive's practice of scanning print copies of publishers' books to create digital copies and then lending those digital copies to users on a one-on-one ratio between the printed book in the library and the digital copy that loaned was not a fair use. And then some other decisions, Philpott, the use of a copyrighted photo in a different context, not a fair use. In that case, you had a photo of Ted Nugent used in connection with an article, 15 sides. Your daddy was a conservative. Totally different context, not a fair use. Greiner v. King, holding that former Congressman Steve King's unlicensed use of plaintiff's copyrighted template photograph for the Success Kind internet meme was not a fair use. This is one of numerous cases arising out of elections where politicians use copyrighted works in a different context. And in general, those kind of different uses are, at least under current law, less likely to be found fair. Again, fair use is very fact specific, so it depends on the particular context. And then finally, Santos v. Kimmel. This is only a district court decision, but it's an interesting one. This involved Congressman Santos, the man who lied perhaps more than typical politician in getting elected to Congress and was eventually impeached and removed after his conviction for fraud. And Jimmy Kimmel's unauthorized use of his personalized celebrity message service message constituted a fair use. In order to earn money, Santos signed up for one of those services where you can hire a celebrity for a few $100s or a few $1,000s, depending how popular the celebrity is, to provide personalized messages such as "Happy birthday, John," and Jimmy Kimmel used that message for comedic purposes, and the district court at least found it to be a fair use. Another area where we continue to see litigation is the intersection between the First Amendment and the Lanham Act. There was a significant 2023 decision from the Supreme Court, and in 2024 we see more litigation, including a major case that I handled. The 2023 decision was V.I.P. Productions v. Jack Daniels Properties. In that case, the Supreme Court sidestepped the very significant circuit split over how to apply Rogers v. Grimaldi and whether it applies at all. The Supreme Court intimated that maybe it shouldn't apply. But in any case, for purposes of the Jack Daniels case, the Supreme Court assumed that the Rogers test applied, but found nonetheless that the decision at issue, which came from the Ninth Circuit, was not appropriate for Rogers because the defendant used the plaintiff's mark as a trademark, and therefore Rogers v. Grimaldi didn't apply. So where does this leave the law? Interestingly, where it leaves the law is it doesn't address whether Rogers v. Grimaldi applies or not. And here in the Ninth Circuit, where I practice and where Berkeley is headquartered, Rogers v. Grimaldi is very much the law. But the V.I.P. decision changes Ninth Circuit Rogers v. Grimaldi law. The way I look at it from a flowchart perspective is whether Rogers v. Grimaldi applies, you need to look at the existing Ninth Circuit case law, which is this chart that I have in the perspective. Is the work protected by First Amendment? Does the secondary use have some artistic relevance? Very low standard. And if so, is it explicitly misleading? High standard. And if you go through this flow chart, you either end up with the First Amendment holding, or you go back to the regular Lanham Act decision. But onto this chart, it graphs a new requirement that if the defendant, go back here, if the defendant uses the plaintiff's mark as a mark, then Rogers v. Grimaldi doesn't apply. So that's the law as we have it now. And we've seen a couple of decisions, the Vans case, finding that Rogers v. Grimaldi didn't apply. These are the Ninth Circuit cases. And the significant Ninth Circuit decision was mine, involving Punchbowl v. AJ Press. That's an interesting case. I represent AJ Press, which publishes Punchbowl News. If you are a political junkie or you work inside the Beltway, you're very familiar with Punchbowl News and its cutting-edge reporting. Oftentimes, Punchbowl News breaks political stories before other media sources. The reason it's called Punchbowl News is because the Secret Service code name for the U.S. Capitol is the Punch Bowl, because if you actually look at the U.S. Capitol, it looks like an inverted punch bowl, and therefore they call it the Punch Bowl. And so Punch Bowl News plays off that kind of insider term. Only insiders inside the Beltway knew that the Capitol was called the Punch Bowl, and so they wanted to convey this sense that they're providing an insider's perspective on news relating to the U.S. Capitol. We were sued by Punchbowl, the online greeting card and bar mitzvah and wedding planning service, first for counterfeiting, which seemed a little aggressive. If you look at the two apps here, it's hard to see much difference. They have a different color scheme, different logos. And of course, Punchbowl News typically uses the slogan "Power People Politics," and it's got the logo there, the inverted punch bowl with a nonpartisan violet color. In any case, Punchbowl sued, and initially they sued us in the the Eastern District of Virginia, and I was able to get that case dismissed for forum shopping. Thereafter, we won at the district court under Rogers v. Grimaldi. Ninth Circuit affirmed, then vacated because of the V.I.P. decision. The mandate was stayed. I had wished actually they'd not stayed the mandate because Punchbowl would have sought cert and we would have had a cleaner First Amendment issue for the U.S. Supreme Court. In any case, it ended well for my client. The mandate was stayed, and what happened was we went back to the district court. The Ninth Circuit eventually decided in 2024 that they would have to vacate their earlier ruling giving summary judgment to my client, Punchbowl News, because of the Supreme Court decision, because Punchbowl News claimed a trademark in Punchbowl News. I argued that under the Supreme Court decision in V.I.P., the question was not whether the defendant claims trademark protection, but whether they're using the plaintiff's mark, which we were not here. We simply claimed a trademark in Punchbowl News, but the Ninth Circuit nonetheless vacated, indicating strongly that there might be a motion to dismiss or summary judgment. And then later in 2024, in the 2024 decision you see there, we won under traditional likelihood of confusion factors, got summary judgment. Punchbowl appealed, and in just this month, in February 2025, Punchbowl dismissed its appeal. So the case is over, and that's where we are. Another issue where we see IP litigation is NFTs. NFTs were very popular until all of a sudden they weren't because the market fell out. But I think we're going to see a resurgence of that. President Trump was reelected on a platform of encouraging cryptocurrency. Trump himself issued his own Trump $sign coins right before he was inaugurated to cash in on his political status, generating very substantial revenue. And so we're likely to again see a resurgence of IP claims as we saw earlier. In fact, even in 2024, we still have litigation over the Hermes v. Rothschild case that actually raised a Rogers v. Grimaldi issue, but in the Second Circuit, Rogers v. Grimaldi issues are decided in conjunction with the traditional Lanham Act likelihood of confusion test. And so it was decided differently than it probably would have been decided in the Ninth Circuit under the more pure First Amendment Ninth Circuit test. And then again, of course, after V.I.P., the question in that case would have been, was the defendant artist using plaintiff's mark as a trademark? And here you have a digital visual display artist creating Hermes bags that obviously do not look like the famous Hermes, the famous Birkin bags. But in any case, Hermes was successful in obtaining a permanent injunction. And in 2024, there was even litigation over whether these bags could be displayed at an art exhibit in Sweden. So the issue continues. There also are contract issues that apply. We saw that earlier in the Tarantino case, and a lot of the contract issues depend more narrowly on the contract at issue. Let's turn to secondary IP liability and the CDA. Again, a lot to talk about. There's been so much litigation in 2024, a lot to keep those of us who litigate in this space very busy, a lot to keep those of you who are transactional lawyers busy. Again, this is another eye exam chart. I put this here to make it a little bit easier for me to cover these issues quickly. We have for any secondary claim of copyright, there frequently is a DMCA defense if the service provider complies with the DMCA provisions. And there are also potentially, you could have case act claims. Interestingly, in 2024, we had a new decision in the Sony v. Cox case. This is a long-running lawsuit that we've seen over the years generating multiple decisions. In that case, Sony, the court found that Cox was not entitled to the DMCA defense because it had adopted essentially a 14-strike policy rather than a 3-strike policy. And 14 strikes starts to sound a lot more like cricket than baseball. The DMCA imposes the requirement on service providers in order to be eligible to benefit from the safe harbor protections of the DMCA. They have to adopt, maintain, and reasonably implement a policy of terminating repeat infringers in appropriate circumstances. Courts have generally upheld 3-strike policies because Americans like baseball, and even though the statute doesn't reference anything about 3 strikes, it just talks about repeat infringers, courts have uniformly held 3-strike policies to be reasonable. So in that case, Sony got an eye-popping copyright decision. I believe it was the largest in history, but then it was vacated by the Fourth Circuit. They affirmed the jury's finding of willful contributory infringement, but remanded for a new trial on damages because Cox did not profit from its subscribers' act of infringement, a legal prerequisite for vicarious liability. So, and another interesting decision on damages and on secondary copyright liability. There is no corollary to the DMCA for purposes of secondary trademark infringement. Nonetheless, since Tiffany v. eBay 15 years ago, courts largely find that intermediaries cannot be held secondarily liable for trademark infringement if they do not have notice or actual knowledge or reason to know about alleged infringement, and if they take down the material once they acquire that notice. A lot of the efforts to challenge the contours of secondary trademark liability over the last couple of years have focused on direct liability, claims trying to hold defendants directly liable. We see this particularly in the print-on-demand business, where companies not only operate online services, but also often offer back-end print services or outsource those to third parties, or whether they can be held liable for counterfeiting. And we had a significant decision in YYGM v. Redbubble in 2023, holding in the Ninth Circuit at least the willful blindness that gives rise to copyright liability for trademark infringement purposes requires the defendant to have specific knowledge of infringers or instances of infringement. So that's a little bit different than copyright law. It's got to be knowledge of specific infringement, like the infringing file, or specific infringers. That's a little bit different than the DMCA. But again, it's also very service provider protective in the sense that it's not enough to simply say, my work is on your service, get it off. In 2024, we saw a district court decision denying cross motions for summary judgment. Court found the scope of the injunction to be improper, but did find that liability was appropriate. So that case continues in litigation. There was also in 2024 a decision also involving a print-on-demand company, Atari v. Printify, in that case denying a TRO, finding Atari unlikely to prevail on the merits against a print platform provider. In the trademark area, there's also potentially the innocent printers exemption that you need to be aware of. In the patent infringement area, there's no particular corollary, but I and my team were successful for eBay in the Blazer case a number of years ago in establishing that, again, absent a court order, simply alleging that something on a platform infringes a patent is not enough. Now let's turn to the CDA. And there's been a lot happening in that area. I mentioned at the outset of the presentation that there is now a renewed risk of regulatory enforcement from the FCC. We also see case law, including some decisions from a circuit or two finding the CDA inapplicable, particularly in product liability cases. And we see a lot of litigation involving product liability, both involving online sellers and social media companies. Really a lot happening in that area. I defend a lot of cases that turn on the CDA, and we see a renewed upsurge in litigation in that area. So let's start with the basics. 47 U.S.C. 230 has a couple of different provisions. The one most hotly litigated is C1, provides that no provider or user of interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. There's other provisions that also apply. Preempts inconsistent state laws, excuse me, including defamation and privacy, and some federal claims, including federal statutes, but it excludes federal criminal claims, claims under ECPA or any similar state law, and any law pertaining to intellectual property. There are a host of issues there, to the extent that you're dealing with the intersection between the CDA and IP rights. I'll have more to say about that in a moment. And that particularly implicates state, not exclusively, but particularly implicates state right of publicity, trademark, trade secret, and other claims. And then it also excludes claims under FOSTA or SESTA for advertising claims involving sexual trafficking. That largely is of concern in the sexual content business, particularly for online escorts, which typically is a niche business that doesn't involve most technology companies, but FOSTA SESTA can implicate even generic tech companies to the extent you're involved in advertising, unless you have an advertising pre-review program or do other things to make sure that unintentionally third parties don't put you in violation under FOSTA SESTA. So let's talk about some recent cases, because there have been a lot of significant ones in 2024. And two trends, I mentioned product liability. The other trend is a lot of cases brought on behalf of minors. And we see that with MP by and through Pickney v. Meta Platforms. That's a Fourth Circuit decision. That one actually is from just this month. Talk about a year in review being absolutely current, and the slides being current, from February 4th of 2025, holding that the CDA preempted claims for negligent strict product liability and negligent infliction of emotional distress for improper content. That Meta's use of an algorithm to deliver content was integral to its publishing function and did not take it outside of the CDA. Very significant decision. Fourth Circuit has historically, going back to 1998, always been one of the circuit's most strongly protective of the CDA. We see in the Ninth Circuit several decisions that continue to some extent to whittle away at the CDA. The Ninth Circuit case law on the CDA is less clear than circuit case law in other circuits, because the Ninth Circuit continues to find Swiss cheese-like exceptions, holes that it can bore into the fabric of CDA case law. Estate of Bride v. YOLO, a decision from 2024 holding that the CDA precluded claims that YOLO's anonymous extension was inherently dangerous and that the company was on notice that its application was dangerous to teenagers. Very good decision, involving this general trend to hold intermediaries liable for things that happen to minors, and trend to try to bring product liability-like claims but holding that representations, remoderation decisions were actionable outside the CDA. This is a broad expansion of a narrow exception that the Ninth Circuit recognized almost 20 years ago, in a narrow exception finding that notwithstanding the CDA, if an interactive computer service undertakes by contract to do something more than it's required to do by law, then it can be sued for breach of the contract, and the CDA does not preempt that claim. That was considered to be a pretty narrow exception, and for that reason, interactive computer services frequently do not vary their reported terms when lawyers reach out and say, well, couldn't I just speak to someone at your client? Maybe they can, surely they understand this is a problem and it's unjust and they can make an exception. And the reason most service providers don't make exceptions is because of this Ninth Circuit decision. Well, in a state of Bride v. YOLO, the Ninth Circuit held that even moderation policies, not just express contractual provisions, can take a service provider outside the scope of the CDA. It's a bad decision in terms of policy because it discourages service providers from adopting good policies to moderate content. And what it does really is it is a further discouragement to companies to moderate, and yet another reason to let content exist without moderation, which means that trolls can take over and can overwhelm content, fake information can prevail, and it creates a bad user experience. But this is the decision, and it's a significant one. On the other hand, we have in Calise v. Meta Platforms a decision holding that the CDA preempted plaintiff's unfair competition claim premised on a duty to root out fraud. In the 11th Circuit, in MH on behalf of CH v. Omegle.com, we have a court holding that FOSTA SESTA exception to CDA claim preclusion did not apply where the parents of a sex trafficking victim alleged merely that the service knew that predators used its services, enabled individuals to communicate with complete anonymity, and did not require age verification or parental consent for minor use, and did not sufficiently protect users' data. This is, excuse me, a significant decision, and one consistent with other 11th Circuit case law that also for decades has found on similar cases where minors have been abused online, terrible facts nonetheless found that intermediaries under the CDA are immune from liability, and liability in tort for these terrible claims really belongs with those responsible, not the neutral platform. So again, a good decision from a technology service provider decision. On the other hand, the Third Circuit in Anderson v. TikTok issued a very concerning decision from the perspective of interactive service providers, holding that TikTok's algorithm, which decided whether third-party speech on the platform would be included or excluded from a compilation, and organized and presented the included items on personalized feeds, was TikTok's own expressive activity and thus outside the scope of the CDA. Now, that decision runs contrary to decades of case law from essentially every other circuit. So it's a very significant decision, and it screams out for en banc review. In any case, the narrow ruling allows product liability, negligence, and wrongful death claims asserted by the mother of a user who died participating in a challenge depicted on a video feed to go forward. Again, inconsistent with rulings from the 11th Circuit, rulings from from the Ninth Circuit, rulings from around the country, Fifth Circuit earlier in time, and so a very significant and concerning decision. On the other hand, in ABV Salesforce, the Fifth Circuit decision from 2024, the court held that the CDA did not immunize Salesforce from claims brought by sex trafficking victims, alleging that Salesforce knowingly benefited from participation in a sex trafficking venture under the Trafficking Victims Protection Act and Texas Civil Procedure and Remedies Act by providing cloud-based software tools and support services to an online advertising forum that facilitated sex trafficking. And this decision, I think, is not so much consistent with Anderson, because it really isn't, as illustrative of the breadth of the exclusion for the FOSTA SESTA created when FOSTA SESTA was passed. FOSTA SESTA creates an exclusion to CDA protection, and as I mentioned earlier, the risk area for legitimate service providers like Salesforce really has to do with advertising, where you can't fully control what third parties are doing, and that I think we see in the Salesforce opinion. Finally, in Ray social media, adolescent addiction, personal injury, product liability litigation case. This is a case in litigation, the district court. It's one of many cases involving product liability that are making their way through the courts. And it is in a way a mixed bag under the CDA. The broad holding is very good. Meta's design, development, and deployment of certain products, even though the court found it plausibly constitutes unfair or unconscionable practices, nonetheless insulated. Section 230 insulates the design and deployment of most of the features alleged to be unfair or unconscionable. Similarly, Section 230 protects against personal injury plaintiffs, consumer protection, concealment, and misrepresentation theories to the same extent. Broad ruling, good, but then there are a number of things found outside the scope of CDA, and really means that these kind of product liability cases, when brought against platforms, can become very fact specific and involve a lot of really a lot of extensive litigation, at least in the Ninth Circuit. The other place where we see product liability cases is in litigation involving marketplaces. Many of these cases involve Amazon, but also eBay and Walmart and other marketplace providers. The companies have largely prevailed. I've prevailed on behalf of eBay. Amazon has prevailed in a number of them. There are some decisions, though, finding Amazon finding the CDA inapplicable to Amazon, but Amazon nonetheless entitled to prevail because the particular state product liability law doesn't apply to it. Excuse me. But there are a couple of bad decisions, particularly in California. The Loomis and Bolger decision. On the other hand, you have better decisions like the Steiner decision from Ohio, finding Amazon not a supplier. The last area where we see a lot of litigation is the intersection between the CDA and intellectual property, and it's shown on this slide. We talked about the exclusions from FOSTA SESTA. It also excludes any law pertaining to intellectual property. What is or isn't a law pertaining to intellectual property is subject to a circuit split. The Third Circuit construes a law pertaining to intellectual property narrowly to just be federal claims, and therefore the exclusion does not. Yeah. Excuse me, sorry. Therefore, in the Third Circuit, sorry, the Ninth Circuit it construes it narrowly based on a federal law, and therefore, in the Ninth Circuit, state claims are not excluded and therefore potentially precluded by the CDA. A lot of words there: excluded, precluded. The Third Circuit, on the other hand, construes the term pertaining to intellectual property broadly, and therefore any claim pertaining to intellectual property, not just federal but state claims, are outside the scope of the CDA. And the key decisions there are Perfect 10 and Enigma Software from the Ninth Circuit, and HEP from the Third Circuit. Then there's a question, the Defend Trade Secrets Act, those claims are subject to CDA preclusion because even though the statute is silent, as I explain in the excerpt from my treatise that I provided with this webinar, the legislative history makes clear that the Defend Trade Secrets Act was intended not to be a law pertaining to intellectual property. That is the kind of oxymoronic thinking that only our Congress could provide, because of course the Defend Trade Secrets Act is an IP law. Nonetheless, for purposes of the CDA, it's not a law pertaining to intellectual property, meaning you can have the anomalous situation where if someone sues an interactive service provider in the Third Circuit for state and federal trade secret claims, the trade secret claim under state law could proceed while the Defend Trade Secret Act claim would be precluded by the CDA, and it results in these anomalous rulings. So let's turn now in the time that remains to data privacy, cybersecurity breach, ad tech putative class action litigation, and online and mobile contract formation and mass arbitration. There's a lot that one can say in this area. I chair an entire day-long PLI conference on this, so I'm going to abridge this pretty significantly. What we've seen in 2024, over 1,500 data breach lawsuits brought against companies. What we're seeing is a huge uptick in data breach class action litigation, and as a consequence also it's becoming more commoditized. You have more plaintiffs' lawyers who are not expert in the area. You have more firms handling defense. We've seen a lower volume of TCPA cases. I mentioned that earlier. We see a lot of troll activity in the data privacy area, particularly relating to pixels, the TikTok pixel, the Meta pixel, the X pixel, also still referred to as the Twitter pixel, and other cases brought under state privacy laws in the handful of states that require two-party consent to allow recording. We also see a lot of litigation under the Illinois Biometric Information Privacy Act, and increasingly the Genetic Information Privacy Act. I don't think those claims work so well, but I have defended a number of those claims. This is what we see. We also see an increasing number of states adopting comprehensive state privacy laws. And even though only California provides a private cause of action, or in Washington under health law, what we see is that this implicitly impacts concepts of negligence, because whatever the standards are, whatever is reasonable under the circumstances changes as more and more states require different provisions, even if the laws themselves don't afford a private cause of action. I've included slides that talk about the type of claims and what we on the defense side typically try to do. In my practice, I try to compel arbitration if that's possible. Again, unless there's a risk of mass arbitration, in which case maybe we don't. We try to win on summary judgment. There are really an array of ways to chip away at these kind of claims. A big issue, though, increasingly, is the intersection between mass litigation and mass arbitration. These are the type of claims that are brought. I've included on these slides some more recent decisions. For example, the Excellion case from 2024, talking about negligence. We see efforts at securities fraud, But a lot of the security breach and data privacy claims that are brought are typically consumer claims. They don't fit necessarily all that well in federal statutes, but plaintiffs try to bring state claims. The Illinois Biometric Privacy Act, it continues to be one that vexes defendants because it allows for broad statutory damages, and it's construed very broadly. We also see a lot of litigation of the Video Privacy Protection Act. There's been an upswing of those cases in 2024, something to be aware of. And in all these cases, as I mentioned, try to get rid of on a motion to dismiss if we can. There's a question of whether you want them consolidated. Sometimes you do, sometimes you don't. In data breach cases, for example, in this area, in the Dickies case a couple of years ago, I was lead counsel for Dickies. We had 7 cases. Plaintiffs wanted them consolidated in California. I argued that 7 was not sufficient for MDL consolidation. We were able to defeat a motion for MDL consolidation. And then one by one, we either resolved or got transferred the other cases until all of the cases were in the Northern District of Texas. There is a general rule of thumb for consolidation that when you've got a data breach, often the home jurisdiction of the defendant where the data breach occurred is often a good, convenient venue. Not determinative, but there's a lot of case law finding that. On the other hand, sometimes even on the defense side, we want MDL consolidation. In 2024 in the In Re 23andMe customer data security breach litigation as lead counsel for 23andMe, I was successful in arguing for MDL consolidation. We had over 40 lawsuits. You had some Illinois plaintiffs arguing that they did not want MDL consolidation because they wanted to keep the Illinois cases with high statutory damages separate and in the Northern District of Illinois, but the MDL panel agreed with me and transferred all of the cases to the Northern District of California. What we're seeing in 2024 and 2025 increasingly is cases like that where you have both mass litigation and mass arbitration, and you need to decide how you want to handle that. First of all, it requires you to consider at the outset what you want to do with your online contracts and arbitration provisions. Some companies, but not most, but some companies have simply dropped arbitration, and now they will only litigate claims because they're more concerned about the threat of mass arbitration, where class action lawyers, based on the fees involved, can force a company to incur far more than what's at issue. There are things you can do. I don't have any silver bullet. There is no silver bullet, but I've worked with dozens of companies, and there are things you can do based on your own risk factor. If you've got the risk of high dollar litigation, then you can do attorney's fee shifting provisions. If you're likely to be dealing with low dollar claims where the non-refundable fees are going to exceed what's at issue, you can put in a provision that would allow recovery of fees if you make an offer before arbitration that's rejected, and then the plaintiff in arbitration cannot recover anything more than what they rejected beforehand. And an array of things in between. I also typically provide for 30 days advance notice and an opportunity to confer. That's helpful in troll cases. But also from a litigation perspective, you need to consider just because you've got an arbitration provision doesn't mean you need to move to compel arbitration. You can waive arbitration. And I've done that in litigation if you prefer to be there. The problem you have when you're dealing with mass arbitration is sometimes it is the plaintiff's lawyers that will move to compel arbitration, and then you may be stuck. So these are important strategic questions. I can't really deal with all of them on this webinar, but they're important strategic questions that you need to think about. I recommend looking at it every 6 months. Audit what you're doing and change your practices, change your online terms, change your online contracts. That becomes very, very important. In the security breach area, we still have a circuit split on standing. I include an excerpt from my treatise in that area. The Second Circuit tries to harmonize these cases, but I don't think they really can. You really have an honest-to-goodness circuit split. Chief Justice Roberts is a civil procedure nerd, as am I, and I do think eventually he will take one of these cases. I suspect, given the conservative orientation of the court and their ruling in other cases, that they will likely find the narrower view of standing rather than the broad view applied by the Seventh and Ninth and DC circuits to be the one that controls. That remains to be seen. The Illinois Biometric Information Privacy Act is a statute that I mentioned, highly problematic. There have been a couple of developments in 2024, some helpful, some not. The legislature amended BIPA to, excuse me, to provide that a private cause of action does not accrue each time there is a pinging. Previously, a separate claim accrued under the Act each time a private entity scanned or transmitted individuals' information. That is a huge change for the benefit for defendants, because some of the dollar numbers in these BIPA settlements and even in one judgment were just astonishingly high. On the other hand, you continue to have significant decisions. The Zelmer case from 2024, the Ninth Circuit held that BIPA protects both users and non-users of the platform. On the other hand, biometric identifiers must actually identify a person to be actionable. That's a big defense win, and that's very helpful and very important. The new trend, litigation under the Illinois Genetic Information Privacy Act. The Bridges case talks about that from the Seventh Circuit, and more recently, the Coatney 2024 Seventh Circuit case holding that children are not bound to arbitrate disputes based on terms and conditions entered into between ancestry and their guardians. Again, this gets back to a trend I've mentioned where we see more suits brought on behalf of minors, and then you've got a problem here where you've got in this case, Ancestry wanted to compel arbitration, but they couldn't because the court found that minors were not bound by the terms of service. I mentioned troll disputes. We see that in the 10, actually now, well, there are 10 states that allow causes of action in some form, in some context, for where you don't have two-party consent to recording. We saw this litigation. The General Motors case is one of mine, where we successfully litigated. Increasingly, we're seeing claims over pixels. Important decision from 2024, the Massachusetts Supreme Judicial Court held in Vita v. New England Baptist that use of tracking software like the Metapixel and Google Analytics does not violate Massachusetts wiretap law. That's very important. That whittles it down to 9 states, including California and Pennsylvania, where these claims may or may not be brought. There's a bad Third Circuit decision from 2022 finding that under Pennsylvania law, you can have an interception even when the interaction is between a user and the company. So it's a one-party transaction. That's crazy. There have been some decisions in California involving the state pen register law, holding that when a pixel is intercepted, that can state a claim under the state, not the federal, but the state pen register law, like Greeley v. Kochava and Moody v. C2 Educational. And that's a problem because it allows these cases to go forward. I think these decisions are wrong. I think we could fight and win, but usually most companies end up settling if they can't win on the merits, because the cost of settlement is usually less than a motion to dismiss, and not every company is willing to pay us to take these cases on appeal, or at least to judgment in the district court, but some are. And these cases can be won. So it's something to be aware of. You need to look at the settlement strategy when you're dealing with trolls. Do you settle or do you fight? If it's a lawsuit, if you settle, then other plaintiffs' lawyers may know, just by virtue of the case being on the docket, that you settled, you may get other claims. On the other hand, if it's just a letter or if it's a confidential arbitration demand, maybe there's less of a risk to your business model of settling. But again, don't overpay. Every plaintiff has their price. They try to change it up. They try to mix it up. But generally, we deal with enough of these claims where we know what they're worth and what the value is, and then you can make informed decisions about whether to settle or whether to fight. And so you need to think about that. And again, these troll cases, like the big dollar case, is another reason to look at your arbitration provisions and to look at what you're doing. One of the problems in this area is a pixel may fire before you get consent. So even if you're complying with CPRA, even if you're complying with every consent requirement in the books, if a pixel fires before consent, then at least under some bad decisions, the plaintiff may be able to state a claim. This is actually a significant decision, the Google case, allowing, determining what a reasonable user is, a very low standard. It's a bad decision under a privacy policy for purpose of a claim. Compare it to Meyer v. Uber, which is a contract case granted from the Second Circuit, and you see that we end up with different results in different cases. CPRA. I am not, I want to warn you or not warn you, but I want to caution you. A lot of companies overpay to settle these cases because because of the $750 statutory damage. But if you look at the elements from my treatise, not any case, but from my treatise, you need to show causation, and it's got to be as a result of a business's violation of the duty to implement and maintain reasonable security procedures and practices. I don't have time to get into it, but I argue in the cases that I'm dealing with that a plaintiff is not going to be able to get that without going to trial, and that involves a lot of risk. That's very difficult for plaintiffs and for the class action lawyers' business model. Let me skip ahead here. I've talked about online and mobile contract, and I've talked about the need to look at these issues because judges continue to impose what I would call higher than black law requirements on mobile and online contract formation, and that's a problem. And then you have this issue of mass arbitration. And I mentioned there are a number of things we can do to help you if you want to have an arbitration clause, but you're worried about mass arbitration. But I would look at the Heckman v. Live Nation case from the Ninth Circuit. In that case, finding a clause unconscionable. You have some decisions like that where if the clause is too elaborate, if you use test cases, if you stay the arbitration to allow the test case to go forward, if you have an unduly long pre-arbitration negotiation period, it may be unconscionable in the Ninth Circuit. I've always said to clients, rule of thumb, it needs to be really simple. If a judge has difficulty determining what applies, if you switch from one provider to another, depending on the number of claims made, it may be unconscionable, it may be unenforceable. So there's a lot you need to look at here. It's an important strategic decision. I work with clients on this, advising them to revisit this at least twice a year, because there are just too many decisions, too many changes in practices, and that those are sort of the drafting tips. Let me stop here. Feel free to reach out to me by email or phone call or social media. Happy to answer other questions. It's always a pleasure and a privilege to speak at the Berkeley Center. This is one of the finest institutions, and it's just a real honor to be here. So thank you so much.
Ian, as always, thank you for joining us, for donating some time. You didn't disappoint. The changes from last year are substantial, and I suspect the changes for next year will be substantial again. So I hope to talk to you next year.
One thing we can always count on, it's an area where things change rapidly.
That in this field, definitely. So thank you so much for your time.
Thanks, Wayne. My pleasure.